So I thought I would take some time and stop during my morning walk this morning to do a video about the change of venue paperwork that just hit the website. Yes, Judge granted a motion to change venue. Most of it, though, was like I predicted. It was based on logistics, and we'll go through that. Also, something that we do know is it's not going within the same district. So it won't be going to Nez Perce County. I know some content creators felt it was, but Judge would not have put the request up to the Supreme Court if it was staying within the district. So we can go over the Idaho Code about that after we look at this document. Okay, the introduction just basically lays out when he originally filed for the motion to change venue and then when the hearing was held. And then it goes on to this next section that gives the background, talking about the murders, and then Kohberger when he was arrested and charged with the 4 counts of murder and the 1 count of burglary, and how the media outlets descended upon Moscow and news coverage quickly focused on Kohberger. And then they go on to talk about the conduct order for the courtroom, the non-dissemination order, and then the cameras, where only 1 camera would now be allowed in the courtroom. And the next session goes into evidence, and he breaks down the highlights of each of the people that spoke at the change of venue hearing and his key takeaways from their testimony offered by each. And I'll let you pause and read a lot of this. So what he gleaned from Murphy was that the possibility of a Latah County resident being exposed to media coverage of the case is much higher than the probability of an Ada County resident being exposed to media coverage. Then it was Dr. Amani El-Alayi, and you can pause and read about her testimony. And here's some more about her testimony. And the judge says, taken together, Dr. El-Alayi stated that in her expert opinion, the best way to ensure Kohberger is tried by a fair and partial jury is to find jurors who are both physically and psychologically removed from Latah County. Then he goes on to talk about Edelman and Edelman's testimony. You can pause and read. And he says, based on the results of his surveys, Dr. Edelman opined that in his expert opinion, there is a responsible likelihood the presumption of guilt prevails in Latah County and that a change of venue is appropriate. And then there isn't much for Dr. Dare because all she testified to was the validity of the survey. Oops, and I accidentally left this page out of Edelman's testimony. So I'm posting it so you can pause and read that. And then he talked about media articles and video clips and how the defense submitted numerous media articles and clips demonstrating the sheer coverage of volume. It says, while some of the mainstream reporting has been appropriate and based on information from the court record, there has been extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. Then he talks about the standard. The Idaho Constitution and the United States Constitution protect a defendant's right to a fair trial by impartial jury. And Idaho Criminal Rule 21 allows transfer of a case for certain instances. So you can read through that, and he cites some case law. And then he talks about analysis and talks about prejudice. So in deciding a motion for change of venue, the court determines whether in the totality of the circumstances, juror exposure to pretrial publicity will result in a trial that is not fundamentally fair. And you can read on through this. Talking about the Supreme Court considers the following factors: existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place, the testimony of jurors at jury selection regarding whether they had formed an opinion upon pretrial publicity, whether the defendant challenged for cause of any of the jurors finally selected, and the nature and content of pretrial publicity, and the time elapsed between pretrial publicity and trial. So it says actual prejudice. In evaluating actual juror prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at the trial had such fixed opinions that they would not judge impartially the guilt of the defendant. So that's some more case law there. You can pause and read. And it says, in reviewing case law, a finding of actual juror prejudice rests on an examination of the jury selection process. This includes evaluating how jurors answered screening questionnaires, the testimony doing voir dire of the veneer, as well as the whole of the jurors eventually seated, and any jurors seated despite a for-cause challenge by the defense. So I highlighted this section here because it says here the defense argues the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey of some 400 county residents, Latah County residents who are anonymous, did not answer questions in court, and were not subject to the questioning by the state. Without attempting to seat a jury, there is no real evidence, such as juror screening questionnaires and testimony during voir dire, for this court to evaluate actual prejudice. So he is saying they can't evaluate actual prejudice. All they can go off of is presumed prejudice, and that's the next section. So he says, unlike with actual prejudice, a finding of presumed prejudice means that the court need not consider juror screening questionnaires or testimony during voir dire before declaring a jury verdict void, or in this case, declaring a change of venue appropriate based on prejudice. It is the defense's burden to establish a reasonable likelihood prejudicial news coverage prevented or will prevent a fair trial in violation of the Sixth Amendment to the U.S. Constitution. And you can pause and kind of read this next section. And it says, in Idaho, courts consider the existence of affidavits indicating prejudice or absence of prejudice in the community where the trial took place. It's basically repeating that same section again about time elapsed between all the coverage and the trial. And here is some more case law, and then him talking about how the relatively small size of the community and the population. The state argues this is enough to impanel an impartial jury of 18 individuals. The defense argues that the small, tight-knit community makes it impossible. Mr. Murphy said 36% of all mainstream news coverage in this case throughout Idaho has been in Latah. Coupled with the smaller population, this makes the probability of Latah County residents' exposure to such coverage higher than Ada, Bannock, or Canyon. Talks about Dr. Ella Lee. Then he goes on to talk about how it's undisputed that there has been significant media coverage. The defense provided the court with 1,222 pages of news articles covering the case from one local area. Talks about quotes from students at Washington State University, coverage of Kohberger's arrest. And it says, finally, while the court does not have affidavits demonstrating prejudice in Latah County, the court must consider the results of the survey Dr. Edelman prepared. Again, while the presumption of guilt was similar across all counties surveyed, the number is more impactful in Latah County given the smaller population. Some 67% of Latah County survey respondents believe Kohberger is guilty, with 51% indicating it would be hard for Kohberger to convince them of his innocence. While similar percentage answered those questions in Ada County, the impact of those numbers when considering population size are drastically different. So he's talking about how in Latah County, if you have 24,000 residents who are eligible for jury service, if 50% of those are disqualified, then that's only 12,000 individuals remaining. Then you have excuses for hardship. He brought up illness, breastfeeding, loss of wages, etc. Thus, when considering prejudice in Latah County, the population size, you have to put it together with the survey. The court is concerned that the venue is, if it's not changed now, it will be asked to reconsider its decision during jury selection, which, if granted at that juncture, would very likely result in the trial being delayed many months. Considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in this case, and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change the venue for presumed prejudice. Now, he talks about convenience and interest of justice. Says even without a finding of presumed prejudice, venue in this case must be changed for the convenience of parties and witnesses, and it's in the interest of justice. And that's what I had said. He was going to change it no matter what for logistical reasons. So he goes on to talk about Latah County court staff and court security. While they're ready and willing to facilitate this trial, there are serious issues that cannot be resolved no matter how much planning and preparation is done. Says the Latah County Sheriff's Office, which is fully staffed, simply lacks the number of officers needed to provide security for the trial, while also performing their day-to-day duties of patrol and responding to calls. One solution is to ask Idaho State Police and Moscow Police to help. However, they were heavily involved in the investigation, and it is anticipated several of their officers will be called to testify. Both of those agencies are also understaffed. Pulling local officers away from their normal duties for 3 months would potentially put Latah County community at risk. So it talks about how in the case of a natural disaster, wildfire, large emergency, etc., they would just not have the staffing. Similarly, Latah County does not have enough court clerks to efficiently manage the jury selection process. It is anticipated that general qualification questions would need to be sent out to some 6,000 individuals, and the clerks would be tasked with entering all that information. And you can pause and read the rest of that. Then it says, further, the Latah County Courthouse itself poses significant issues for a trial of this length and magnitude. The courthouse lacks the space needed by both the state and the defense. While the state has a dedicated space within the courthouse, they would still be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Meanwhile, the defense does not have a dedicated space within the courthouse, and there are limited options available. Also talks about how the jury room is crowded with 12 to 13 jurors, but for 18 jurors, which you would need to have for a murder trial, because you have 6 alternates, they said for 3 months it would be uncomfortable at best. Additionally, the door between the jury room and the courtroom is not soundproof. Further, court security would be tasked with trying to bring the jury into the courthouse in a fashion that ensured the jurors' privacy while also ensuring the court privacies. The only options for bringing the jury into the courtroom is through the public hallway or directly past the court chambers. Neither are good options. Further, there is also the issue of the continuing day-to-day operations at Latah County Courthouse. The magistrate judge will continue having hearings, district judge, blah, blah, blah. So, business has to go on at the courthouse, and they only have 3 courtrooms in there. It says, while traveling to another county for 3 months is indeed inconvenient for the attorneys of the court, some family members of victims, and some witnesses, having the trial at the Latah County Courthouse would be inconvenient in numerous ways, and beyond that would present serious safety risks. Thus, the interest of justice requires the trial be moved to a venue with the resources, both in terms of personnel and space, necessary to effectively and efficiently handle a trial of this magnitude and length, so that the parties in the court can focus on the case and not on peripheral issues. And then his conclusion says the change of venue is granted pursuant to Idaho Criminal Rule 21A and 21B. Consistent with the language of Idaho Criminal Rule 21C 2B, this court orders a transfer of venue without specifying the new place of venue and refers the case to the administrative director of the courts for assignment by the Supreme Court to a proper venue in another judicial district and assignment of a specific judge to preside in the criminal proceeding. So yeah, I called that a while ago, that he was going to change it no matter what for logistics, that the impartiality wasn't really as big of an issue as the actual courthouse size and security. So now we're waiting to find out what the Supreme Court decides. And remember, I said we know it's not going to the same district because it did go to the Supreme Court, and let's take a look at the Idaho Code about that. So you'll see he cited the language of Idaho Criminal Rule 21C 2B. So let's take a look at 21C 2B. Okay, so 21C 2. So if you see, this first page is 21 ABC and then 1. So we've got to go to the next part for 2. So here's 2. And then there's A and B. So he cited 21C2B. So that means a transfer to a different judicial district. And then it says if the original judge does not desire to continue the assignment over the case, the judge must enter an order transferring the case without specifying the new place of venue, and then refer the case to the administrative director of the courts for assignment by the Supreme Court to a proper venue in another judicial district and assignment of a specific judge to include in the criminal proceedings, to preside in the criminal proceedings. So, and a shout out to Dope Soul, because I was actually looking at the civil procedures earlier and not criminal. And so it looked like the judge could have requested to stay in the case based on the civil procedures, but actually this is criminal. So 2B means that he does not desire to continue on the case. So that means we're going to be getting a new judge also, which is going to be really, really interesting, folks.